Hi everyone, my name is Daniel Kriegers. I'm an employment lawyer at Chadwick Lawrence Solicitors. This update focuses on all things national minimum wage and firstly amendments to the National Minimum Wage Regulations 2015 which will take effect from the 1st of April 2021. The changes to these regulations provide increases in the national minimum wage in accordance with the Low Pay Commission's annual recommendations, and also extend the existing 3-year period for which employers are liable to keep minimum wage records for up to 6 years going forwards. So, from April 2021, we must be prudent in our record keeping of salaries and must establish over the course of a 6-year period that payments are equal to or exceed the new national minimum wage rates. Besides those amendments, the national living wage will increase by 2.2% from £8.72 to £8.91 and will be extended to 23 and 24-year-olds for the first time from April. This means that low-pay workers' income should rise broadly in line with predicted wage growth and modestly ahead of projected increases in inflation and prices, meaning living standards arguably should be protected. In addition to these changes, we've seen a significant ruling affecting particularly the care sector this week, and this is with regard to sleep-in workers and their potential entitlement to national minimum wage whilst working and staying perhaps at a service user's property or in a care home. Previous case law has been very inconsistent over a number of years on this point. There was a case of Borough Down Support and Rossiter, where it was held that a night watchman at a care home who was permitted to sleep for much of his shift was nevertheless working throughout the shift and not simply available for work, despite being asleep for most of that time. At one point, therefore, it was considered that workers on call throughout their shift should be regarded as having worked the entirety of that sleep-in. The case of Royal Mencap Society reached the Supreme Court, which is the highest level of appeal court, in 2020, and it's taken around a year for that judgment to be published. The Supreme Court has held that sleep-in workers are deemed to be available for work rather than actually working whilst asleep and at the employer's premises or perhaps a service user's home. So they are not entitled to be paid the national minimum wage for the whole sleep-in shift, but simply for the time that they are required to be awake for the purposes of working. So typically, if there is a disturbance during the night where a care worker has to attend to an emergency involving a service user, at that point, that time that is worked will attract minimum wage rate, but the entire sleep-in shift will not. It's been long awaited in the care sector, given the uncertainty of the law and the fact that HMRC has been pursuing care organisations for historic underpayments based on their previous understanding of the law. What remains to be seen is whether or not there is now legislative change, because from the employee's perspective they are extremely restricted in terms of their movements whilst being required to sleep in at a particular location, and we wait to see whether there is any further proposal for amendment on that front. If you require any advice or assistance on this ruling on national minimum wage generally or on record keeping, please do contact us, employmenthub@chadlaw.co.uk, or alternatively visit the website chadwicklawrence.co.uk. Thank you.